rather emphasized the subjective test in construing the provocative tendencies of words, especially. The court said words may amount to provocation. Words may amount to provocation, but it must relate to the station in life of the accused person. Words can amount to provocation, but it must relate to the station in life of the accused person. Buttressing the subjective test requirement, the court went further. Buttressing the subjective test requirement, the court went further to state that in backward communities, the court went further to state that in backward communities, where the subjection of women is accepted, in backward communities, where the subjection of women is accepted as natural and proper, where the subjection of women is accepted as natural and proper, counting by wife, counting, T-A-U-N-T-I-N-G, counting by wives, such as calling the husband impotent, such as calling the husband impotent, and spitting on his face, counting by wives, such as calling their husbands impotent, and spitting on his face, may arouse more passion. May arouse more passion than in sophisticated societies. May arouse more passion than in sophisticated societies. That's Supreme Court for you, buttressing the subjective test element and talking about backward societies, comparing it with sophisticated societies. Spitting on his face may arouse more passion than in more sophisticated societies. And the court held that the word uttered to the accused, being an administrative secretary in Ibadan, the word uttered to an accused, being an administrative secretary in Ibadan, and Ibadan, which was perceived to be a sophisticated society, in Ibadan, which was perceived to be a sophisticated society, and the accused also being an administrative secretary, was also perceived to be an educated person, enlightened. That the words uttered to the accused could not justify the stabbing by a person in a station in life. That the words uttered to the accused did not justify the stab by a person in a station in life. So we move to the next requirement, which is loss of self-control. Loss of self-control. And the test here is both objective and subjective. And the test here is both objective and subjective. In the sense that the provocative acts or words must not only have induced the accused to lose control, must not only have induced the accused to lose control, it must also be capable of making a reasonable man temporarily to lose his mind. It must also be capable of making a reasonable man temporarily to lose his mind. It is not a statistical test. It is not a statistical test. But the test is whether the conduct of the accused person can be understood sympathetically, though not condoned. Whether the conduct of the accused person can be excused sympathetically, can be understood sympathetically, do not condone. Hence, the loss of control must be situated within the context of the accused person. The loss of the self-control must be situated within the context of the accused person. And here we are talking about the reasonable man of the accused background. Reasonable man of the accused background, or stature, or his status in life, or his status in life as a sophisticated person, which will be judged differently from a person, from a primitive, less refined person, which will be judged differently from a person, from a primitive, less educated, and less defined background. And the test is to be determined by the expectation from a person having the power of self-control of an ordinary person who is of the same sex and age of the accused. The person must have the capacity to control himself within the context of the sex and age of the accused person. The accused person will be judged by a reasonable man of his status, of the same sex and age. However, if a reasonable man will lose his self-control, if a reasonable man will lose his self-control, and the accused person did not lose his, then the defense will not avail the accused person. So a reasonable person must be capable of losing his self-control. Then the accused person must actually have lost self-control. So you have to take note of that. It is not only when a reasonable person is expected to have lost self-control. The test also extends to the fact that the accused person must have actually lost his self-control. So in the case of R versus Adekami, is 1944. Okay, see the case of R versus Adekami, 1944. 17 NLR at 99. Adekami is 1944. 17 NLR at 99. Then we also have R versus Igiri. Igiri is IGIRI. 1948, 12 Waka. 1948, 12 Waka at 377. At 377. In the case of Ruma, Ruma is spelled RUMA versus Daura Native Authority. Ruma versus Daura Native Authority, 1960. 5 FSC at 93. In the case of Ruma versus Daura Native Authority, 1960, 5 FSC at 93. A woman likened a Muslim to a dog. A woman likened a Muslim to a dog. And it was held by the Federal Supreme Court that it can amount to provocation. It was held by the Federal Supreme Court that such statement can amount to provocation. However, the court held that if the parties are non-Muslims, it may not lead to provocation. The parties are non-Muslims, it may not lead to provocation. In Beda versus DPP, 1954, to all Nigerian law report at 809, Beda is spelled B-E-D-D-E-R. B-E-D-D-E-R versus DPP, 1954, to all Nigerian law report at 809. The accused, who was sexually impotent, the accused was sexually impotent and tried unsuccessfully to have intercourse with a prostitute. The accused was sexually impotent and tried unsuccessfully to have intercourse with a prostitute. The prostitute jeered at him and kicked him. The prostitute jeered at him and kicked him. He descended on the and the prostitute died. He descended on the prostitute and the prostitute died. But the court held the accused guilty of murder. This was a badly decided case. The court held the accused guilty of murder. So if we apply this case of Beda to the principles that we have enunciated concerning the subjective and objective test, jeering at an impotent man, is it not sufficient to make the impotent man lose self-control? Can somebody answer that question? Hello?
Yes, sir.
Aha. So the decision in Beda was jettisoned in a subsequent case. The decision in Beda was jettisoned in a subsequent case because the court failed to adopt the standard of a reasonable impotent man. So in the subsequent case of DPP versus Camplin, in the subsequent case of DPP versus Camplin, Camplin is spelled C-A-M-P-L-I-N, 1978, to all
DPP versus who?
DPP versus Camplin. DPP versus Camplin, 1978, to All England Report 168. The law lords directed that the decision in Beda should be jettisoned. The law lords directed that the decision in Beda should be jettisoned. In Camplin, the defendant was a 15-year-old boy. The defendant was a 15-year-old boy who was raped by a man. He was raped by a man, and the man taunted him about it. He was raped by a man, and the man taunted him about it. The defendant beat up the man to death. The 15-year-old boy beat up the man to death. It was held that defense of provocation availed the defendant. It was held that the defense of provocation availed the defendant. So the defects in Beda's case was cured in Camplin. Take note. So we move to the last requirement, which is the requirement of proportionality. And this is a bit controversial. Requirement of proportionality. And this requirement is contained in section 284 of the Criminal Code. This requirement is contained in section 284 of the Criminal Code. And it is required, the it is required that the degree of retaliation must be commensurate with the provocation offered. The degree of retaliation, which actually leads to the death of the deceased, must be commensurate with the provocation offered by the deceased. Proportionality requirement, in essence, is the act of balancing the provocative act of words. Is the act of balancing the act of words with the reaction or deed of the accused person. The act of balancing the provocative acts of words with the reaction or deed of the accused person. In George versus the state, in George as in body George versus the state, 1993, 6 SCNJ, 1993, 6 SCNJ, part 11, at 249. At 249, the court held that the beating of the accused, and scattering of his burdens were not such acts which would cause in an ordinary man of the same standing as the accused a sudden and temporary loss of self-control. Supreme Court held that beating the accused and scattering his burdens were not such acts which would cause in an ordinary man of his standing a sudden and temporary loss of self-control, rendering him subject to passion. Rendering him subject to passion as to make him for the moment not master of his mind. Not master of his mind. The court held that the martial blow to the head of the deceased was disproportionate to the provocation offered. The martial blow to the head of the deceased was disproportionate to the provocation offered. And in arriving at this conclusion, in arriving at this decision, the court took cognizance of the instrument with which the homicide was committed. The court took cognizance of the instrument with which the homicide was committed. Somebody beat up the accused. We were not told that he used any instrument, maybe with his hand, and scattered his burdens. And you now say you are provoked. You headed for a machete and used the machete to attack the person, and you kill the person. The court took cognizance of that instrument that was used, that it was disproportionate to the provocative act offered to the accused person. So you take note of that under the proportionality test. But like I said, it is a very controversial requirement, simply because you require that somebody must have lost self-control. And you are still expecting that person who has lost self-control to be reasonable enough in measuring the quantum of force that is offering to counter the provocative acts that has been offered to him. The law requires that the accused person must have lost his self-control. So when you have lost your self-control and you are still expected to weigh your actions so that it will not exceed the provocative act that is being offered to you, you can see that it sounds, illogical. But what do you think? Hello? Hello?
Yes, sir.
Yes,
Does,
sir.
does it
Sir,
not sound
Yes, sir.
illogical?
sir, I think I have
Yes, sir.
a
It sounds
slightly
illogical.
diverting opinion, sir.
It's like expecting somebody to be reasonable in a state of unreasonableness.
Sir, I
Yes,
think
sir.
I have a slightly diverting opinion, sir. I
You
have a
said what?
distorting opinion. I think I have a slightly different opinion,
Yes,
sir.
what is your opinion?
Yeah, okay, sir. So I think although it sounds a bit absurd, but I think it could make sense in scenarios where the provocation that was offered could have been retaliated on with maybe an act of like just the person with the use of maybe his hands, and then the person goes out of his way to get a very like a very like an object that can inflict very terrible harm, and then in that case it might seem disproportional, even though the state wants to give him the defense of provocation, but then
If
the
you look at
malicious
the case
act
of
of
George, if you look at the case of George, though it addresses the issue of proportionality, but it was mainly based on loss of self-control. You see, it's a consequential requirement. You must have, first of all, lost your self-control. And what they were saying in George is that beating the accused and scattering his burdens will not suffice to make him to lose his self-control. Okay? So the issue of proportionality is a consequential requirement upon loss of self-control. And what some legal minds are actually interrogating is whether somebody who has lost his self-control can still be in a situation to evaluate his action towards ensuring that he has not exceeded the level of force that he's supposed to use to repel a particular act, provocative act. So in the case of R versus Phillips, or Phillips versus R, in the case of Phillips versus R, in 1969, 2 AC 130. In the case of Phillips versus R, 1969, 2 AC 130, where the counsel to the accused raised the poser. The counsel to the accused raised the poser whether once a reasonable man has lost self-control, once a reasonable man had lost self-control, his actions can still be expected to be that of a reasonable man. His actions can still be expected to be that of a reasonable man and should be fully responsible in law for whatever he did. And I should be fully responsible in law for whatever he did. So in the case of R versus Adelodun, R and Adelodun, 1959, 21 NLR at 76, the accused, who was provoked by abusive songs against his family. The accused, who was provoked by abusive songs against his family after the loss of local government election, he was provoked by the abusive songs against his family after the loss of local government election by his cousin, claimed that he lost self-control and he killed one of the singers. He claimed that he lost self-control and killed one of the singers with a machete cut. He killed one of the singers with a machete cut. Autopsy report revealed that severe cuts killed the deceased. Autopsy report revealed that severe cuts killed the deceased. The court held that provocation defense failed proportionality test. The court held that the provocation defense failed proportionality test. So we have concluded defense of provocation. On that note, we have concluded defense of provocation.
Sir, please, I have a question.
Yes, what's your question?
Okay, so sorry to drag us back a bit, but I've been raising my hand since. I wanted to know if that law that was, or the law in Roma against Daura State, Daura Native Authority still applies, because it seems rather discriminatory that, especially what the judge said, that if it had applied to a non-Muslim, maybe the person would not be able to use the defense of provocation.
The law is still applicable. The law is still applicable. I gave you an example that we have set a question before, where a Muslim was sitting by the window side in a bus, and there was a Christian sitting beside him who was drunk. He took alcohol, he was drunk. And when the bus was moving, he felt like vomiting. And in the process of pointing his mouth towards the direction of the glass, the window, he vomited on the body of the Muslim. And the Muslim drew out a dagger and wanted to stab the person. And I told you that in that kind of situation, defense of provocation may avail the Muslim, because Muslims detest alcohol. I'm talking of genuine Muslims now. I know some Muslims take alcohol, but genuine Muslims detest alcohol. They detest pork. They detest dog meat. That's why sometimes there is a Yoruba proverb that Ebony wants to affect me itaja to feel come limomu. They detest it. So a deaf and dumb also detest a situation where you put leaf in your mouth. So there are certain peculiarities, and that is what we mean by subjective test. However, if the guy sitting by the window side were to be a Christian, the defense may not avail him, because the way the Muslims detest alcohol is not the same way the Christians, detest alcohol. Especially, you did not even pour the alcohol on him, you vomited. So you see, when you look at that, you don't talk about the issue of discrimination. Talk about the issue of subjective test. You understand? So Roma versus Daura Native Authority is still a valid, position of law when it comes to subjective test. And if you can recollect, Beda was set aside in Campling. Beda was set aside in Campling. A reasonable, impotent man. A reasonable, impotent man. So, these are the areas that you have to look at. Okay. So that is that. So we want to move on to involuntary manslaughter now.
Sir,
Yes, what's your question?
Okay, thank you, sir. So I get your point on if the parties were to be a Muslim, maybe the position would have been different. So in past questions, when I was going through them, there was a particular question that the guy's name is Kabir. So I don't know, can we infer from the name?
When you hear Kabiru, don't wait till they tell you in the hypothetical question that Kabiru is a Muslim. Because Kabiru is a Muslim name. So you're already guided to know that Kabiru is a Muslim. If they say the person sitting beside him is Johnson, Muslims cannot be Johnson. So they are already telling you that both of them are Muslim and Christian. So they won't tell you expressly that Kabiru is a Muslim. Are you satisfied now? Uh-huh.
Yes, sir, but like in this case, you're talking about dog meat or Muslims eating pork or alcohol, but in this case, it was urine. So I wanted to know if that counts, because if the Kabir brought out a dagger too.
It was urine.
Yes, sir.
The issue of urine, I think urine can even pass for both Christian and Muslim.
Yes, sir.
You understand what I'm saying?
Yes,
Urine
sir.
is not a peculiarity of a particular religion in terms of being detected. An average person will play off if somebody urinates on you. I think the guy was pressed. The guy was pressed, and the bus driver did not wait. Maybe he now points his penis towards the window,
Window.
and
Yes,
the
sir.
urine drops on the guy sitting by the window side. So sincerely, that is not. It doesn't have any religious bias. It will pass for both Christian and Muslim.
Sir, so you think the dagger is proportionate?
Well, as far as I'm concerned, he has lost his self-control. That is where you have to argue.
Okay.
Analytical reasoning now. Well, you people are not so big. You see, when you hear Kabiru, Muslims, especially these headers, these people that are maybe headsmen, they always accompanied with their dagger. They put their daggers by their side. That's another dimension. An average Christian doesn't go around with dagger. But an
Yes,
average
sir.
Muslim, especially the headsmen, they are known for going around with dagger. So that's what he has on his body.
Okay, thank you, sir.
So maybe that's why they are trying to take proportional for Kabiru to use dagger. Because Christians are not known to be going around with dagger.
Hello, sir.
Yes?
So, actually, I want to see things in a real form, the reality of what we are talking about apart from the academic nation. Would the judgment in that case, I mean, the case the former person quoted about the Muslim that was provoked because the person called him or her a dog. How would you, I don't know, in the reality, would the Supreme Court be supporting an easy, provocative response to even a mere or an easy, or let's say something that is just like we normally hear some time ago, like 2 years ago, an Okada man who is a Muslim had issue with another person. Before you know it, he was provoked. Wouldn't the Supreme Court be supporting a prompt provocation, an easy provocation that can happen to anybody? And when you are provoked, immediately you can get out your dagger and kill the other person. I don't know how you see that Supreme Court injunction, whether it is supporting
I can
an easy
assure you
provocation.
that decision in Roma may not stand if the accused person is an enlightened and sophisticated Muslim. I don't know if you understand what I'm saying.
Yeah, I'm getting you.
If the accused person is an enlightened and sophisticated Muslim, he will probably not react. Most likely will not react. He will be more accommodating. I will just try to overlook the fact that they call him a Muslim. Unlike an illiterate, primitive, naive Muslim, who will see it as an abomination. So that is, we are looking at subjective test requirement now, and that is, you look at the Muslim in the status of the accused person, in life, the educational background, and the ex-men are illiterates, So let's quickly look at involuntary manslaughter because of our time.
I
Yes.
have a question.
Yes. What's the question? That's the last one. Go move on. Yes.
Question.
Yeah,
So, sir, okay.
Okay.
Okay, so sir, the question I have is a follow-up of the last speaker. I feel in a way these tests are a little bit um harshly tolerant of certain behaviors, because I would like to imagine that um this test should be subject to the fact that as humans we should be able to tolerate each other, right? But then it's also it looks like it's giving a free hand to certain behaviors on the defense, with the defense of peculiarities in, like, I don't know if you understand that. So the question I'm trying to ask, sir, is for the purpose of the exams, is it is it will a student who argues in the opposite direction with sufficient submissions be able to make quality mark, or do you just have to go with what?
It depends. It depends on what you mean by quality marks. The student may not necessarily fail, but he may not have quality marks. Because you may argue and argue wrongly. So we have marking scheme, and the marking scheme will have said this is the answer. But sometimes we also say students who argue the other way convincingly can also be compensated. I don't know if you understand what I'm saying.
Yes, sir.
It's not a straight jacket way of yes or no. When you are taking a position and you justify it and it looks convincing, you still get something, but not as much as somebody who made the point that we are actually expecting as examiners.
All right, thank you, sir.
So you look at when you are talking of tolerance, Look at the case of Green, Al versus Green now. Assuming when the man came to the mother-in-law's house and saw the man friend making love to his wife, and there is a bottle of beer beside them, he breaks the bottle and stabs the man to death. Will you say that the defense of occasion will not avail him, or that it will have been tolerant? But it was because he went away for like 4 hours and came back with a machete to now attack them. That was how it failed. If it had been spontaneous, he would have succeeded. So we move to involuntary manslaughter. When I started manslaughter, I told you that manslaughter can either be voluntary or involuntary. Okay, voluntary manslaughter is when defense of provocation, mitigate the offense of murder. Then it should be commuted to manslaughter. And the advantage there is that rather than being sentenced to death, which is the capital punishment that is prescribed for the offense of murder, you are now going to face life imprisonment. Which does not necessarily mean that you will be in prison to the end of your life. It can be reduced depending on the discretion of the judge and the circumstances of the case. Somebody has been sentenced for manslaughter before, and he got as low as 3 years imprisonment. Some will get 5, some will get 7, and some can get 20. So it's the discretion of the court. So when we talk of involuntary manslaughter, it can arise in any of the following 3 ways. 1, it can arise in any of these 3 ways. 1, where the accused caused the death. Where the accused caused the death in circumstances that it did not intend to kill nor cause grievous bodily harm. Where the accused caused death in circumstances that it did not intend to kill or cause grievous bodily harm. If you look at your section 316, subsection 1, where we are talking about the menstrual element of murder, you will see that subsection 1 is saying that it should be construed that you have formed the mental element of the offense of murder if you intend to kill somebody and the person dies. And subsection 2 says if you intend to cause grievous bodily harm. But now we are looking at a situation where somebody did not form any intention to kill, but it ends up killing. So that person will be suitable to be classified under involuntary manslaughter. And what distinguishes this from voluntary manslaughter is that under voluntary manslaughter, there is intention to kill. But that intention is vitiated by the defense of provocation. You are provoked and you decide to kill and you kill. But under involuntary manslaughter, there is no intention to kill, but death results. Are you following me now? Aha. The second instance is in circumstances that he did not foresee death as a probable consequence. This is a foreseeability test now. He did not foresee death as a probable consequence of his conduct. But there is blameworthiness. There is blameworthiness such as gross negligence or recklessness. And examples of these are medical profession and reckless driving. Medical practitioners and reckless driving. Let me give you an example of this. Let me give you an example. Because we are still going to look at specific. Maybe a doctor, medical doctor that has performed a surgery on a patient. And in closing up the body of the patient, he negligently left some of the apparatus that he used, instruments, inside the womb, not deliberately anyway, inside the womb, and that can lead to the death of the deceased. So by doing that, it's an act of gross negligence, and it can be construed as involuntary manslaughter if it leads to the death of the patient. Then you see somebody driving on the highway where they say 60 kilometers per hour or 100, and the person is on 150. The person is on 150, and somehow he loses self-control. He loses control and beats somebody that is standing at the bus stop and kills the person. He did not foresee that he will kill a person, but he has been negligent in his action. So in that kind of situation, it will also fall under this category. Then the third one is where death results from unlawful act, which involves the risk of harm to another. Where death results from unlawful act, which involves the risk of harm to another. So when we are talking about death that results from performance of dangerous or illegal acts, there is this case of Attorney General Western Nigeria versus Oyelade. Attorney General Western Nigeria versus Oyelade. It's a 1966 case. NMLR 407. Death resulting from performance of dangerous or illegal. You see, example of this is those who are committing abortion. You know, abortion today is outlawed, is prescribed. There are only few instances in which abortion can be carried out legally. Otherwise, abortion is illegal. So if you try to carry out abortion, even if you are a medical doctor, and the patient dies in the process, then you are coming under this manslaughter act, about this manslaughter charge, because you have engaged in dangerous or illegal act. So in the case of Oyelade, the accused, a native doctor. The accused was a native doctor, and he was invited to treat the disease of his swollen scrotum. The deceased had a swollen scrotum. So the accused pricked the swollen scrotum with a needle. He pricked the swollen scrotum with a needle, squeezing out some liquid. He was squeezing out some liquids from the swollen scrotum, and he also gave some liquid to the patient to drink. He also gave some liquid to the patient to drink. So the deceased died later of injuries to his testes. The deceased died later of injuries to his testes and scrotum. So the accused was convicted of manslaughter. The accused was convicted of manslaughter. So also on automobile manslaughter, there's also what we call automobile manslaughter. You see the case of R versus Layiwola. Layiwola is 1960, WNR, 1960, WNLR at 77. Layiwola is 1960, WNLR at 77. And in this case, the accused was driving fast in a zigzag manner. The accused was driving fast in a zigzag manner. Hello?
We can hear you, sir.
The accused was driving fast in a zigzag manner along a road. And in the night, when pedestrians and other vehicles were moving, and he overran the deceased. He overran the deceased, driving in zigzag manner. He overran the deceased. It was held that his conduct showed complete criminal disregard for the lives and safety of others. It was held that his conduct showed a disregard for the life and safety of others, and he was convicted of manslaughter. Also, in Amusa versus the state, Amusa and the state is 2003. One SCNJ at 518. The appellant here drove a taxi car and left his lane. The appellant here drove a taxi cab and left his lane and he swerved to the right side. He swerved to his right side, where his car knocked down a pedestrian, and the pedestrian died instantly. The Supreme Court affirmed his conviction for manslaughter. And you see, there is a more recent case that is in all force, with this case. And that's the case of Ibinabo Fiberesima. Some of you might have heard about the case. This was a lady, I think she was an actress or a former Miss Nigeria or something like that. She was coming from a club somewhere in Lekki, Axis. And she was very drunk. And she was driving in the morning, going home. She slept off and crossed the demarcator that is by the middle of the road, and crossed to the other side and hit a medical doctor, Dr. Giwa. Her for manslaughter. The magistrate was swayed by the status, the social status, the economic status of the accused person. In convicting her, he gave her option of fine of 100,000 naira. And that attracted a barrage of criticisms and condemnations. So the state took over the case. She was rearranged at the High Court, properly charged. After paying the 100,000 fine, she was rearranged at the High Court, properly charged, tried, and convicted, because she was sentenced to 5 years in prison. She has gone on appeal to the Court of Appeal. Court of Appeal upheld the judgment and sentence of the lower court. And as I'm talking to you now, Fiberesima is before the Supreme Court on appeal. And you can always imagine what will be the outcome of the case, because the medical doctor's life has been wasted due to reckless driving, And the defense of intoxication cannot avail because it was not, involuntary. It was a voluntary intoxication. So voluntary intoxication is the only one that can avail, not involuntary. I mean, it is only involuntary that can avail, not voluntary. So that is the situation in that case. So we also have
Sir, please, sir, can you help us repeat the case? Ibinabo and who, sir?
Ibinabo Fiberesima. She's a very popular person in the society. She must have been a former Miss Nigeria or actress or something like that, a social figure. The case is presently before the Supreme Court. You know, so it's either maybe it is state versus Fibrosima, but I don't have the citation. It's still before the Supreme Court. You know, it has passed the Court of Appeal. It's now at the Apex Court. So we also have R versus Kojo. R versus Kojo is 1958, LLR at 69. R versus Kojo, 1958, LLR at 69, which has to do with driving with defective steering and bad brakes. It has to do with driving with defective steering and bad brakes. And of course, if you drive with defective steering and bad brakes, and in the process, your brake fails and you kill, you will be guilty of manslaughter. And you can compare this case with the case of State versus Anu. Anu is ANU. State versus Anu is 1976. 1976. 6 UILR at 166. 1976, 6 UILR at 166. Where the accused who had a sudden burst of tire that caused accident and death was acquitted. The accused who had a sudden burst of tire that caused accident and death was acquitted. You know, it also depends. Sometimes we can have manufacturers, defect. You can buy a new tire and you may be traveling and you may have a burst. You know, it happens. Are you aware that it happens? Hello?
Yes, sir.
Yes, sir.
So it depends on the state of the tire. If the tire is a good tire, but you have a burst and you kill, in that case, you can raise a defense of accident under Section 24 of the Criminal Code. But if the tire is worn out, this is a matter of evidence. If the tire is worn out and you are still using it and you have a burst and you kill, you'll be liable for manslaughter. So in this case of State versus Anu, the tire was apparently in good condition. That's why the court acquitted him. Otherwise, he would have been guilty of manslaughter. Just like someone who has a defective brake and defective steering. So now we'll talk briefly about medical negligence. Medical negligence. And I'm commending to you the case of Adomako versus R. Adomako is spelled Adomako versus R is 1995, 1AC 171. Adomako and R, 1995, 1AC 171. Where an anesthetist, that's the medical doctor that is carrying out surgery, you administer anesthesia, so that you deaden the parts that you want to operate on. So the anesthetist failed to notice the disconnection of a tube. The anesthetist failed to notice the disconnection of a tube from the ventilator. You see that's medical negligence. We're talking about life and death. The ventilator, the ventilator is a device, that gives you artificial means of breathing pending your recovery. If you cannot breathe naturally, But the medical doctor who plugged the ventilator failed to notice that it has been disconnected. He was held guilty of manslaughter because the patient died as a result of that disconnection. So you can also see cases like R versus Akerele. R versus Akerele is 1941, 7 Waka. R versus Akerele, 1941, 7 Waka at 56. And State versus Okechukwu, 1965, 7 ENLR at 91. And State versus Okechukwu, 1965, 9 ENLR at 91. It's 9 ENLR. 1965, 9 ENLR at 91. the cases border on medical negligence and involuntary manslaughter. So on that note, we draw the curtain on homicide. We have discussed murder, as it were. We have discussed attempted murder. We have discussed manslaughter within the context of voluntary and involuntary manslaughter. As per voluntary manslaughter, we have discussed extensively how the defense of provocation can avail you to commute a charge of murder to manslaughter. And the difference there is that instead of facing the penalty of death sentence, you can face a life imprisonment penalty. Okay? And it is voluntary because there's intention to kill or cause grievous bodily harm, and you have killed. We also have in our discussion involuntary manslaughter, which can be caused by your engagement in dangerous or illegal acts. As I actually pointed out to you, in the case, as I earlier pointed out to you in the earlier case of Oyelade, Attorney General Western Nigeria and Oyelade, who was engaged in a dangerous and illegal acts. And I've also given you instances of automobile manslaughter, and of course, the examples on medical negligence. So these are involuntary manslaughter. So now we want to proceed to sexual offenses, and we are starting with rape.
Please, before we proceed,
Hello?
I have a question.
Yes,
Involuntary
what's your
manslaughter.
question?
Okay, sir, the last example you gave about the medical personnel
Yeah.
being careless about the ventilation tubes. In a case where, for example, the cause of the patients being in the hospital in the first place was by an involuntary act or was by an act of another, like for example now, in an accident or maybe when someone probably hit the person and put that person in that position. Maybe the person failed to check his brakes or something like that and caused the accident to happen. And the person that ended up in the hospital, and what's it called? And that situation happens where the medical personnel forgets to, connect the ventilation tubes and all. So that there are two people involved now: the person that hits the victim and the medical personnel who forgot to, connect the ventilation tubes. So is it both? Who exactly will be held responsible for the manslaughter? Is it the medical personnel or the person that caused the accident initially?
As I will answer your question, but I expected that you should have been able to understand this in the context of break in the chain of causation. Okay? Is there any novus actus intervenience? I taught you novus actus, which is a variant of break in chain of causation. Okay? And novus actus is a situation whereby there is a supervening act that actually or probably accelerates the death of the victim. And if the chain is broken, then the principal person that caused the injury, which will have led to the death, is discharged. But if the chain is not broken, then it's liable. Okay? You can still recollect R versus Jordan, and you can recollect R and Holland. Okay? Now, as we speak.
So, sir, does that mean that even though he caused
let me learn. I've not finished. I've not finished. There was a particular year I gave you a question where somebody was on admission and the person will have died in the next 1 hour. But the medical doctor went to smoke close to a generator plant. And after smoking, he dropped the butt of the cigarette and close to the petrol tank of the generator. And it got ignited, and there was a fire incident that engulfed the whole hospital, and the patient who would have died in less than 30 minutes time was burned to death in the inferno. So are you saying that the chain has not broken? So I would have died naturally if the fire did not happen. So the person who started the cause of things will now be charged for inflicting grievous bodily harm. But the person that ignited fire is now liable for murder. But it now depends. It's going to be manslaughter because it was not intended. It was not foreseeable, reasonably foreseeable. But because of negligence and recklessness, he will still be guilty of manslaughter. You understand? So the case you have just mentioned too, as somebody sustained injury, he was taken to the hospital, but the medical doctor, you see, if you can still remember your Jordan and Holland, we are talking about a situation where proper medical attention was given. So if proper medical attention was not given, and another disease sets in, maybe like lockjaw or infection, which actually now accelerate death or leads to death, the chain will be broken. But if there is proper medical handling, then the chain is not broken. So if you still have clarification now, let me know.
I understand now,
Hello,
sir. Thank you.
Okay. So
hello,
we're talking
sir. I
about.
have another question, sir.
Yes.
I have a
Quickly.
question, sir, concerning loss of control, where you said the test here is both objective and subjective, and then you talked about the reasonable man. I'm a bit confused about something when we are talking about the reasonable man, because you talked about the better case where it was wrongly decided because they did not take into consideration the reasonable impotent man test. And I'm wondering, how exactly do we even get the test of the reasonable man? Does the judge say, okay, I feel a reasonable man should do this, or I think a reasonable man should do this, or they just bring somebody that is not involved in the case to use as a test of reasonable man? I don't understand how we really get the test of reasonable man. How we really get the reasonable man's test in this situation?
Yes, when we talk of objective and subjective, objective is a situation whereby you are talking about a reasonable man in the shoes of the accused person. His status in life, his academic background, religious background, exposure, sophistication, and so on and so forth. But when you talk about a subjective test, you are talking about the accused person himself. Either he has certain peculiarities that must be put into consideration towards ascribing culpability or otherwise to him. So that is just it. Objective is a reasonable man in his shoes. That one is abstract. You just figure out somebody who has the qualities, qualifications, and attributes of the accused person. But when you talk of subjective, you are talking about him as a person. I hope it's clearer now.
Yes, sir. Thank you very much,
Okay,
sir.
so quickly, let's start with this offense of rape. I think I have about 12 minutes to close today so that we can just kickstart the topic and take it further on Thursday. Okay, so when we talk about rape, I said we are going to talk about sexual offenses, and there are quite a lot of them anyway. But for the purpose of this semester, I'm going to limit myself to rape, indecent assault, and defilement. Okay? Rape, indecent assault, and defilement. So we are going to start with rape. Okay? And we are going to be looking at the typology of the offense of rape. When we talk of typology, we are looking at the nature of the offense, the classification, in your earlier part of your study in criminal law. My colleagues that have taught you the elementary parts of it must have taught you classification of offenses. Is that right? Am I right?
Yes, sir.
So by now, you know which offense is a felony, which offense is a misdemeanor, which one is a simple offense. By now, you know which offense is indictable, which one is not indictable. By now, you know which offense is a violent offense. By now, you know which offense is a property offense. By now, you know which offense is a personal offense, and so on and so forth. So when we're talking about the typology of the offense of rape, first and foremost, we have to underscore the fact that rape is an assault. Rape is an assault. You still have your definition of rape, of assault, that has to do with the unlawful contact with the body of another without the person's consent. And I think, even under the law of tort, they will tell you that rape, assault is actionable per se. You still remember? Actionable
Yes,
per
sir.
se means without proof of any damage. So when you're talking about the context of your assault, you are talking of unlawful contact with the body of another without his consent. Okay? So that is rape for you, and it's an assault, like I said. It has to do with unauthorized contact, with the body of another. Okay? Rape is also a felony. So I want somebody to tell me why rape is a felony. So I will not be the one doing all the talking. Somebody tell me why rape is a felony.
Because it's punishable with life imprisonment, sir.
So what is a felony? What is a felony now? So that we can know whether it falls within the category of felony. Huh? I'm listening. You said what? What is a felony?
It's an offense punishable by at least 3 years imprisonment.
By
at least 3 years imprisonment.
Okay, by 3 years imprisonment or more. That's a felony. And since it is this rape is punishable by life imprisonment, it is a felony. Okay, so that is that. Rape is also an offense against the person. We have offense against property. Can somebody give me an example of offense against the property offense?
Trespass.
Yeah?
Yes.
Example of property offense.
Theft, sir.
Stealing and theft.
Burglary.
Those are good examples of property offenses. But in the context of rape, it is a personal offense because it's offense against the person. Okay? Then, rape is also a sexual offense because it has to do with sex. It has to do with sexual organ. Okay? And finally, rape is a violent offense because by virtue of the definition of rape, it has to do with unlawful carnal knowledge of another without consent. And when you do something without somebody's consent, there is element of force. It's involuntary. So there is element of force, So that's why it is a violent offense. So quickly, let's go to the definition of rape. I'm sure you all have your criminal code and you have your criminal law of Lagos State. So section 357, what does it say? Section 357 of the Criminal Code. It says, and I read, any person who has unlawful carnal knowledge of a woman or girl without her consent, or with her consent if the consent is obtained by force or by means of threat or intimidation of any kind, or by fear of harm, or by means of false or fraudulent representation as to the nature of the act, or in the case of a married woman, by impersonating her husband, is guilty of an offense which is called rape. So you have that definition like that. You can leave out the space. After the class, you go and write it out from the Criminal Code. But it suffices at this juncture to actually pinpoint salient components of this definition, which we are going to be discussing one after the other. So the very first important element of that population, of that definition, is the phrase any person. Any person. Then we are also going to interrogate what is unlawful carnal knowledge. It's talking about unlawful carnal knowledge. Then it also says of a woman or a girl. Of a woman or a girl. Then there is also this aspect that says without consent, or where the consent is vitiated by force, threats, intimidation, representation as to the nature of the act, fear of harm, or fraudulent representation as to the nature of the act. Then there is also a place it says, in case of married woman impersonating her husband. Now, the relevant statutory provisions, like I said, is Section 357 Criminal Code, Section 258 Criminal Law of Lagos State, Section 285 Penal Code, Section 357 Criminal Code, Section 258 Criminal Law of Lagos State, Section 285 of the Penal Code. So now, let us interrogate the use of the phrase any person. In the definition as espoused in Section 357, when you say any person, is it not a misnomer? Because any person can mean a man or a woman. But the offense of rape, within the context of the criminal law and the criminal code, is an offense that can be committed only by a man, not by a woman. It's an offense that can be committed only by a man, not by a woman. Because it contemplates that any gender can commit rape against a woman or a girl. Whereas rape under the criminal code is a male offense because it requires what we call penile penetration, which can only be occasioned by a man or a male. So this anomaly has been cured by the Criminal Law of Lagos State 2011, and the phrase any person has been changed to any man. If you look at the definition in Section 258 of the Criminal Law of Lagos State, it used the phrase any man, not any person, that was used in the criminal code. Because it is now any man is gender specific. And it ordinarily implies that only a man can rape a woman and not conversely. Then the question is, who is a man? The next issue we are interrogating is who is a man? And this borders on capacity. You know, Section 30 Criminal Code exempts a boy who is below the age of 12 from having capacity to have carnal knowledge. Any boy below age 12 is duly incapacitated when it comes to the offense of rape. Okay? But in the criminal law of Lagos State, the age of 12 was reduced to 10. That is what we call the age of irrebuttable presumption. The age of, is rebuttable presumption. age of 7 or so is irrebuttable presumption, but age of 10 or 12, as the case may be, is the age of rebuttable presumption. Rebuttable in the sense that if the person has a big body, you can say that he has, but when it is below 7, whether he has a big body or not, it is irrebuttable. It must be presumed to have capacity. So Section 30 Criminal Law of Lagos, they reduce the age of presumption to below 10 years. The implication of that age limitation is that any male below the age of 10 years is totally incapable to have carnal knowledge of a woman or a girl. Now, the former position was that there must be actual penetration and that the penis must have gotten to a particular spot within the female genitalia before penetration can be established. So when you look at that, then you can also get what I'm talking about. So now we are going to look at the actus reus element and the mens rea element of the offense of rape. But before then, it suffices to state at this junction that the mens rea requirement of the offense of rape is intention to have unlawful carnal knowledge. Intention to have unlawful carnal knowledge. We are still going to look at what carnal knowledge is. But unlawful carnal knowledge is to be accompanied with knowledge of lack of consent. Knowledge of lack of consent. So absence of consent is very, very germane, when you are establishing the ingredients of the offense of rape. And it is also for the prosecution to prove absence of consent, which is very difficult. Then the limitation on any man committing rape is further pronounced. Yes. You said what?
Sir, we have a class now, sir.
Okay, it's already 9:30. Okay, our next class, just remind me that we stopped on, that we're about to start actus reus of rape. That we're about to start actus reus of rape. So enjoy the rest of your day.
Thank you very much, sir.
Okay.
Thank you,
All
sir.
right. You're welcome. Bye.
Thank you, sir.
You're welcome.
Thank you very much.
You are most welcome.
Thank you, sir.
Hello?
We are still here.
We're still here, sir. Goodbye, sir.